Now let's continue our video lecture on modes of discovery. So in this video, we are covering Rule 23, 24, 25, 26, 27, 28, and 29. Let's talk about the concept of discovery first of all. Discovery is a mode of making the parties arrive at disclosures of their evidence, disclosures of what the other party knows about the facts in issue. So here the purpose of discovery is to obtain information from the other party and or certain persons who will be the witnesses or prospective witnesses or deponents. Okay, and the purpose of discovery is to permit mutual knowledge before trial of all relevant facts. So this is again still in preparation for trial, and there are several ways of exercising one's right to avail of different modes of discovery. Now, there are six kinds of modes of discovery. Number one, depositions pending action. Number two, depositions before action or pending appeal. Now, you must distinguish these two. The first one is there is already an action. Kaya ang tawag depositions pending action. Yung pangalawa, depositions before action is filed. There is no court case yet. Or pending appeal. And then letter C, interrogatories to parties. Letter D, admission by adverse party. Letter E, production or inspection of documents or things. Letter F, physical and mental examination of persons. So let us first deal with depositions pending actions. Like I said, in this situation, there is already a court case that was filed. Now, even if there is a court case, so a party is just preparing. Nagpe-prepare pa lang siya for presentation of evidence, or the party wants to elicit some disclosures. So, Section 1, it tells us when can a deposition pending action be taken? Upon ex parte motion of a party, meaning a party may file a motion without need of having that motion set for hearing. The testimony of any person, whether a party or not, may be taken by deposition upon oral examination or written interrogatories, and the attendance of the witness may be compelled by the use of a subpoena. Okay. The deposition of a person confined in prison may be taken only by leave of court on such terms as the court prescribes. Okay, so as a general rule, this will be allowed without any leave of court. Pero ang exception, kapag prisoner, then of course, that will be allowed by the court only when there is a valid reason, a clear, legal, valid reason for allowing deposition to be taken with respect to a prisoner. And ano yung scope of the, again, who are the parties to be examined? Section 1, whether either a party to the case or not. So pwedeng the plaintiff may move for the deposition taking of a defendant or any other person. Okay, compare this with Rule 24, Rule 25, interrogatories to parties. Okay. Parties lang ang pwede sa Rule 25. Now, dito sa first sentence nakalagay, the deposition may be taken upon oral examination or written interrogatories. Yung oral examination, parang it will seem like there is a trial. Kaya lang, it is not conducted in court. It is conducted in a place outside the court. So, there is a pending case. Merong witness na kailangan kunan ng deposition. Let's say the case is filed here in Quezon City, and then the witness is in Apari, Cagayan. Okay? Pwedeng i-take yung deposition ng witness doon. Kaya lang, hindi naman pupunta yung buong court sa Apari, Cagayan. So, the deposition of the witness can be taken before any person who is authorized to take deposition, such as a judge there in Apari, Cagayan, or a notary public there, or a person who is authorized to administer oaths there. Okay? So, oral examination or written interrogatories. Ang lalabas niyan, Pag sinabing oral examination, counsels for the parties will be going to Cagayan. They will appear before the person authorized to take the deposition, like the notary public. And the witness will also be there. So, parang may trial talaga. The, the proponent will take the deposition by asking questions on direct examination, and the other party, the other counsel, will ask questions on cross-examination. Okay, and then pwedeng may redirect examination, may cross-examination. Kapag written interrogatories naman, the lawyers will not have to go to Apari Cagayan, but they will submit their written questions to the person who is authorized to take the deposition. So may questions on direct examination, may questions on cross, may questions on redirect examination, may questions on cross examination. At ang magbibigay lang ng question na yon, ang magtatanong lang is the person who is authorized to administer the deposition. Kasi nga, wala naman yung legal counsel doon. So, the testimony of the person, the deponent will be taken. It will be transcribed. It will be, magkakaroon siya ng TSN, transcript of stenographic notes. Tapos papakita ito dun sa deponent. Titignan kung may correction. Kapag wala, it will be finalized. It will be signed by the deponent. Kung ayaw pirmahan, then the officer authorized to administer oaths will be the one to sign and explain why he was the one who signed. Ngayon, Section 2, ano yung scope of examination? Nakalagay sa Section 2, the deponent may be examined regarding any matter not privileged which is relevant to the subject of the pending action, whether relating to the claim or defense of any party. So, ang criteria kasi sa testimony of a witness, it has to be relevant and it must not be privileged. Yung relevant, meaning it has a direct relation to the issues before the court, the issues that are being litigated in the case. Yung privilege naman, this finds its roots in the rules on evidence on privilege communication or the doctrine of privilege. There are certain relationships which are confidential in nature, such that when a person makes any disclosure to the other person, then nobody can compel that other person to reveal what has been disclosed. Katulad ng priest and penitent, yung nagko-confess sa priests, that is covered by the doctrine of privilege. So the priest and penitent and attorney-client relationship, that is a fiduciary relationship, that's also covered by the doctrine of privilege. And then you have patient and physician privilege. And meron pang husband and wife privilege. Okay? So, yun yung mga limitations ng mga pwedeng i-receive na evidence sa deposition taking. Ngayon, tungkol saan naman ang pwedeng tanungin? Dito nakalagay, anything relating to the claim or defense of any other party, including the existence, description, nature, custody, condition, and location of any books, documents, or other tangible things, and the identity and location of persons having knowledge of relevant facts. Now, so Section 3, sinasabi dito, there will be examination and cross-examination as provided in Sections 3 to 18 of Rule 132. Ayan lang yung in-explain ko kanina. Plaintiff will first present evidence. The witness will be subject to direct examination and then cross, redirect examination, and recross. Okay? Pero, alright, okay, so that's it. And then Section 4, use. Now, may pagkakaiba yung pagtatake ng deposition sa using ng deposition. If you take the deposition of a person, it doesn't mean that that person is your witness. Okay? So, ito yung, but if you use that deposition, that deponent will be your witness unless you use the deposition for the purpose of contradicting or impeaching his testimony or for the purpose of, you do this, you impeach or contradict in order to prove that that witness is not credible. So, kung hindi yun ang purpose, then that person will become your witness. So, tingnan natin, no? Section 4, letter A, any deposition may be used by any party for the purpose of contradicting or impeaching the testimony of the deponent as witness. Okay, for impeachment purposes. Letter B, the deposition of a party or an officer in which the party is a juridical entity, or may be used by an adverse party for any purpose. So, pwedeng gawin niyang pang-impeach or pwedeng gamitin niya as his own witness. Okay? And then, letter C, the deposition of a witness, whether party or not, may be used for any of the following purposes. Okay. So, sinabi natin that this is the taking of a testimony outside of court before a person who is authorized to take the deposition, a person authorized to administer oaths. Pero may mga limited purposes, limited grounds or reasons. Number one, the witness is dead. Okay? So, let us say that you have a person who was injured by using a certain type of medication or because ginagamit niya yung medication na yun, nagkaroon siya ng cancer. Okay? And that person is already in a stage 4 cancer. Okay? And you are intending to file a complaint against the manufacturer of that medicine. Kaya lang, by the time the complaint is filed, baka sa sobrang serious ng illness ng witness na to, hindi na siya umabot, that witness might be dead already. Now, you can use the deposition of that witness in the trial. Okay? Kasi ito under number 1, when the witness is dead, and hindi na siya pwede mag-testify, pero yung deposition niya is available, you can use that. The reason is that witness was already examined before on direct and cross-examination, or kahit hindi siya na-cross, there was an opportunity to cross-examine him, and therefore that deposition is admissible. The second ground is the witness resides at the distance more than 100 kilometers from the place of trial or hearing or is out of the Philippines. Unless it appears that the person offering the deposition was the one who procured his absence. So, di ba pinag-aralan natin sa subpoena that if the witness resides more than 100 kilometers away, pwedeng hindi niya sundin yung subpoena kasi nga napaka-burdensome naman kung pupunta pa siya. So, pwedeng yung deposition niya, if it was taken, that can be offered. So, again, the witness is in Apari and the trial is in Quezon City. Pwedeng hindi na dumating yung witness kasi meron naman siyang deposition. Okay, number 3, the witness is unable to attend or testify because of age or sickness, infirmity, or imprisonment. And number 4, the party offering the deposition has been unable to procure the attendance of the witness by subpoena, kahit trinay niya. Okay, and then number 5, such exceptional circumstances. And then letter D, ang ibig sabihin lang, if part of the deposition is offered in evidence, other parts may also be introduced by any party. Section 5, effect of substitution of parties, nothing. The deposition can still be taken. And then Section 6, objections to admissibility. Okay. Sinabi natin na pwedeng i-take yung deposition in another place, let's say sa Apari, no? And let us say that it is taken before a notary public, pero the case is in Quezon City. So the lawyers will both be there, counsel for both parties will be there. One party will ask questions and the other party will be there to cross-examine. Pero pwede rin siyang mag-raise ng objections dun sa questions. For example, para sa kanya irrelevant yung tanong, pwede siyang mag-object. Kaya lang ang mangyayari dyan, the notary public will not be able to make a ruling on the objections kasi hindi naman siya yung judge. So, ire-record lang yung objections, pero sasagutin pa rin ng witness yung tanong. And then the court that handles the case will be the one to make a ruling on whether the questions are admissible or not. So, Section 7 and Section 8, you must read this together. Section 7 is about the effect of taking the deposition. Section 8 is about the effect of using the deposition. Magkaiba. Section 7, the mere fact that you take a deposition does not make the deponent your witness. Pero Section 8, if you use the deposition, that deponent becomes your witness unless you're using the deposition for the purposes of impeaching the credibility of a witness. And then Section 9, rebutting opposition, pwedeng mag-present. Yeah. Section 10, 11, 12 must be read all together. Persons before whom depositions may be taken. Kapag nasa Pilipinas, you have judge. the judge in another place, not the one that is hearing the case. Okay? And then, pwedeng notary public or a person referred to in section 14, meaning person na in-stipulate ng parties. If the parties so stipulate in writing, depositions may be taken before a person who is authorized to administer oaths. Okay, so the person to take has been stipulated. Sa foreign naman, foreign countries, ito yung mga pwedeng mag-take ng deposition, yung Secretary of Embassy or Legation, and then our consular officers, Consul General, Consul, Vice Consul, or Consular Agent of the Philippines. Pwede rin person or officer appointed by commission or under letters rogatory appointed by the court. That is mentioned in Section 12. Okay? And then yung sa Section 14, person na na-stipulate ng parties. Kaya lang, Section 13, may disqualification by interest. There are certain persons before whom depositions cannot be taken. And one of them is a person who is a relative within the 6th degree of consanguinity or affinity of any of the parties, or a person who is the employee or counsel of any of the parties. The second disqualified person is a person who is a relative within the 6th degree of consanguinity or affinity of the counsel or the employee of such counsel. And the last one is somebody who is financially interested in the action. Okay? Kasi meron silang interest either in the subject or in with respect to the parties. Hindi sila pwede. Okay? Section 15, deposition upon oral examination. The one who wants to take the deposition will be filing a notice of deposition upon oral examination, serve it to the other party, so that the other party will have an opportunity to attend and cross-examine. And then, Section 16, yung court naman, pwede niyang lagyan ng meets and bounds or limitations yung deposition on oral examination para magkaroon ng order, para walang harassment, para walang annoyance, okay, para walang embarrassment or opposition. So, ito yung mga pwedeng ilagay sa order ng court. Pwedeng hindi take yung deposition o kaya sa certain places lang na hindi naman yung sobrang layo sa or burdensome para sa deponent. And then, only on written interrogatories, pwede rin gawing limitation yon, or that certain matters will not be inquired into. The scope of the examination shall be held with no one present except the parties to the action and their officers or counsel, kasi baka confidential yung information, or maybe the deponent is very ill and masyadong mahirap sa kanya kung maraming taong magka-attend. Okay? And then letter F, that after being sealed, the deposition shall be opened only by order of the court. Letter G, secret processes, developments, or research need not be disclosed. And H, the party shall simultaneously file specified documents or information in sealed envelopes. And then the court may make such other order as justice may require. Okay? Record of examination. Yung testimony ng witness will have to be reduced into writing. It will be in a transcript of stenographic notes. And then, like I said, ipapakita sa witness yun. Kung kailangan may ayusin, may i-correct, i-correct ng witness bago i-finalize. Tapos pipirmahan ng witness at saka ng officer who was authorized to administer oaths. Okay. Ngayon, pwedeng instead of oral examination, the parties may submit written interrogatories to the officers who shall propound them to the witness and record the answers verbatim. Instead of going to, let's say, Apari, no? Sa Quezon City in trial, yung lawyers ng parties, hindi na sila pupunta, pero magpapadala sila ng written questions, ang tawag doon, written interrogatories, to the officer who will administer oaths. At yung officer ang magtatanong. Tapos, yung sagot, i-record verbatim. Okay? Motion to terminate or limit examination. That is a reasonable order if that is necessary. Okay? Section 19, submission to the witness, signing. Na-discuss ko na to. And then, the deposition shall be filed by the officer, send it to the clerk of court. And a notice shall be given to the parties. Parties may request for copies of the deposition upon payment of the fees. Now, ito naman, sections 23 and 24, yung mga nag-order, yung mga gustong mag-take ng deposition, na nag-submit ng notice pero hindi naman natuloy yung deposition taking, nagpunta na rin yung kabilang party doon. Yung party, yung proponent, will pay a sum of money to cover reasonable expenses and attorney's fees dahil pinapunta niya yung other party dun sa malayo. Okay? And then section 25, deposition upon written interrogatories. Ito na yung sinabi ko kanina. Instead of the lawyers going to the far place, they will send their written interrogatories to the person who will take the deposition. And that hindi sila mag-iintayan. Isa-send nila lahat ng questions, direct and cross, redirect and recross. Pag nandyan na lahat ng questions, magsaset ng session yung officer and he will be asking the witness the questions at isusulat, ire-record yung answer. Papakita yung answer kung tama, kung may change na kailangan, and so on, and then is-assign ng witness and then ng officer. Okay? Now, the other parts of this, I will leave it up to you. That's very easy to understand. Section 24, depositions before action or pending appeal. So, gusto ko lang i-point out yung sa Rule 23, that is the taking of a deposition when there is already an action. And that is what we call deposition de bene esse. Pero itong Rule 24, depositions before action or pending appeal, wala pang case na fina-file before action, iti-take na yung deposition. Or sa pending appeal naman, there is already a judgment by the trial court and the case is on appeal and the party will just be preparing, baka kailangan ng testimony ng witness na ito. Now, when do you want to take the deposition before action? Let's say a person wants to perpetuate his own testimony because of the future action. Hindi niya alam kung, let's say he was very sick, he doesn't know if he will be strong enough or if he will still be alive by the time the case is eventually filed. He can perpetuate his testimony or that of any other person who will serve as witness. Now, how does he do this? There is no case, right? So he will have to file a petition in court. And the venue for this is the place where the expected adverse party resides. So, iba to dun sa usual rules on venue. You remember sa venue, it is the place where the plaintiff resides or the defendant resides at the option of the plaintiff. Pero pagdating sa deposition under Rule 24, it is the place of residence of any expected adverse party. Okay? So, of course, that is to assure that the expected adverse party will be able to participate. Okay? At least, he was given the opportunity to participate. And then, there are certain matters that must be stated in the petition. You have that the petitioner expects to be a party to an action but cannot bring it or cause it to be brought. And then next, the subject matter of the expected action and his interest. Letter C, the fact that he desires to establish by the proposed testimony and his reasons for desiring to perpetuate. Letter D, names and description of the persons he expects will be adverse parties and their address. And letter E, names and addresses of persons to be examined. So, okay, I mean, that's very understandable. There has to be a notice and there has to be a service upon the other party. The court will issue an order allowing the examination to be made, and then the deposition itself will be filed with the court. Okay, so the mere taking of the deposition does not make the person one's witness, pero pag ginamit, then that will already make the deponent the witness of the one presenting the deposition. Dito naman sa pending appeal, isang provision lang ito, Section 7, the application to take deposition pending appeal will be filed before the court that rendered the judgment. So let's say RTC, the case is already on appeal to the CA, you file your application to take deposition pending appeal with a RTC, not with a CA. And then there are the same. Lalagay mo rin yung ano yung content, sino yung gustong deponent, and what is the reason why the deposition has to be taken. Okay, Rule 25, you have to distinguish this with Rule 24 and Rule 23. Rule 25 refers to interrogatories to parties, questions to the parties. Hindi katulad nung Rule 23, 24, pwedeng deposition of a party or a witness. Ngayon, ang pagkakaiba rin sa Rule 25, walang intervention ng notary public or person authorized to administer oath. Kasi yung question, mismo doon sa parties ibibigay. And then the party will have to answer the question under oath. Okay? And that will be submitted to the court. Pero kung may mga objectionable questions, pwedeng mag-object muna siya bago niya sagutin under oath, and the court has to resolve the objection. And then, doon natin malalaman kung kailangan talagang sagutin or if the question will be stricken out. Okay? Now, admission by adverse party, Rule 26. This is a very important mode of discovery kasi meron dito ang tinatawag na implied admission. Okay? This is filed, no? Yung request for admission, this is filed after the answer has been filed by the defendant. Kasi makikita mo dito sa first clause ng Section 1, it is filed at any time after issues have been joined. And the issues are joined after the defendant files an answer. So what happens here is that the one who makes a request for admission will submit a written request for admission to the adverse party. And the adverse party must answer the same within 15 calendar days from service. There are two matters that can be included in a request for admission. Number one, request for admission of genuineness and due execution of a document. Number two, the truth of a material or relevant fact. Okay? So, pwedeng document, pwedeng fact. And Section 2 is important kasi kailangan i-deny in writing and under oath ng other party yung matters that are being requested to be admitted. Okay? Kapag hindi dinenay within the period given, or kapag dinenay pero hindi under oath, that will be deemed to have been impliedly admitted. Admission is very important in the rules of court, especially in the rules on evidence. Because when you take up evidence, there is a rule that says admissions by the parties in the pleadings and in all trials and proceedings do not require proof and cannot be contradicted unless shown to have been made through palpable mistake. Okay. Now, so that's what's important about a request for admission. And of course, if there is an improvident admission, it may be withdrawn upon motion. And effect of failure to file and serve request for admission, ang ibig sabihin, the other party cannot present evidence on such facts. Punta tayo sa Rule 27, production or inspection of documents or things. This is a motion that can be filed by other party. Of course, good cause has to be shown. And there are two important matters here. The first one is that the party is seeking an order to permit the inspection and copying, photographing of designated documents, papers, books, letters, etc., not privileged, that contain evidence material to the case. The second one, of course, the items have to be in control of the person who is addressed in the motion. Okay, and then the second one is with respect to property or objects. Yung una, dokumento. Ito yung pangalawa, property. So, the movant can request for an order to permit entry upon a specific property in control or possession of the person named there for the purpose of inspecting, measuring, surveying, or photographing the property or the designated object. Okay. Now, Rule 28, this is also important if the subject matter of the case involves the mental or physical condition of a party in controversy. Again, party, okay? Yung who will be the subject of this. So let us say it could be a proceeding for guardianship in which proceeding for guardianship that is filed with respect to a party who is claimed to be incompetent. In that sense, the mental condition of the person is at issue. And what is the objective of this? The objective is for a court order to direct the person to subject himself to physical or mental examination by a physician. Okay, physician, not a psychologist who is not a doctor, not by anybody else, but a physician, a doctor of medicine. Then the court will issue an order for examination specifying the details of the examination and the scope. And the person who conducted the examination must submit a report to the court. Okay? Ngayon, ito, importante ito. After such request and delivery, the party causing the examination shall be entitled, upon request, to receive from the party examined a like report of any examination that was made before or after of the same mental condition. And if that person refuses to give a report, the doctor will not be allowed to testify or his testimony may be excluded. Okay? And then Section 4, okay, balik muna tayo dito sa doctrine of privilege. Diba, yung patient and doctor, they have a fiduciary relationship so that matters that are learned by the doctor in the course of the examination of the patient shall not be subject to disclosure. Kaya lang, etong Section 4 is saying, if the party examined requests for a copy of the report, he is deemed to have waived the doctrine of privilege. Okay? And then Rule 29, refusal to comply with modes of discovery. Pag ayaw sumunod nung taong object of the discovery procedure, such as Section 1, refusal to answer, the court will issue an order requiring him to answer. So, an order to compel an answer. Sa Section 2 naman, pwedeng ma-cite yung person for contempt of court. And then there are other consequences that are mentioned in Section 3. Okay? So, I will just leave that up to you for you to study the details. Kasama na rin dyan yung expenses because gumastos yung other party because of the motion that was filed by the other party, tapos wala namang hindi naman naging productive. So, yung party who did not have any valid reason for refusing to admit will be adjudged liable for expenses and reasonable attorney's fees. Ganun din ang failure of the party to attend or to serve answers. So that is the end of our lecture on modes of discovery. Next, we will have the lecture on trial.